must be check and balance. Yes, some are saying this is powers of legislative assembly. Mana boleh mahkamah pergi. Tetapi tuan-tuan dan puan-puan, isu ini bukan hanya berlaku di Malaysia, di England, di Canada, di Australia. When we went to England to go and get a second opinion with the Queen Counsel, we were given examples. The case of Lord Byng, the case of Prime Minister King in Canada, in Australia. When the MB hilang dia punya keyakinan, he has to resign, and the monarch can invite someone to appoint. I'm sorry, I'm jumping. Okay. Jadi isu yang saudara Hanifah bangkitkan, perintah yang kami pohon, iaitu tentang penggantungan MB dan juga 6 exco dia tak laku, tidak sah, adalah tidak tepat. Sebab apa yang kami dapat di sini ialah satu deklarasi hak. Dia macam kita pergi mahkamah, when you have doubts as to whether harta ni botol ni you punya atau tidak, we go to court and ask a declaration, is this mine or not? And when the court says it is yours, on the day, come the day 7th of May, there is nothing that can stop him or them entering the Dewan, because they've got the highest court order. The only issue now here is how will the assembly take place. Itu saya serahkan kepada politician lah. Yeah? I have few more to share. I have more documents to show, case law, but I think I am left with 0 minutes. So I shall take my seat and I leave it to the moderator again to take us through. Thank you, tuan-tuan.
Terima kasih Dato' Afariza. Now we invite our final speaker for tonight, Mr. Nga. Please, thank you.
Mr. Moderator, ladies and gentlemen, good evening to all of you. You have heard some very interesting and erudite discourses from my two learned panelists, which are certainly beyond my countryside vocal cords to either replay or to emulate. Be that as it may, I want to make some observation for your evaluation. Now, the topic is Perak crisis. It is not difficult for a crisis to be created. In the state of Perak, all they needed was 3 honorable assemblymen or adun to switch allegiance. And the facts of the political crisis has been fairly accurately set out by my learned friend, Dato' Shafi. But there are certain points I disagree with him, especially the meeting between Niza and Tuanku. I will have more to say on that later. As a result of the defection by the 3 aduns, a crisis has been created in Perak. A bull has been let loose, and whether this full-grown bull is a constitutional bull or a political bull is beyond the expertise of the veterinary department to identify. It will require the collective wisdom of all of us to help. What is more important, ladies and gentlemen, is how to resolve the crisis that is already created. Now, there is a saying that one must take the bull by the horns. By Malaysia, certain quarters have an inclination to take the bull by the tail. And in the process of grappling the bull by the tail, he always carries the risk of the fallout from the rear portion of the bull's anatomy. And those who are adventurous enough to venture to help will also find their hands being soiled. Now, let us look at some of the actions taken by different parties in this political crisis. Of course, there is the action by the Perak Speaker, Yang Berhormat Sivakumar, when he received 3 letters of resignation, which he communicated to the Election Commission, and the dispute broke out whether who has the final say on this matter of resignation. It became a legal dispute. And later, there was also a complaint by the honourable member from Canning, and it resulted in the meeting of the Privilege Committee and the suspension of Dr. Zamri for 18 months and the 6th ESCO member for 12 months. Now, ladies and gentlemen, we must bear in mind that Malaysia is a constitutional democratic country. There is 3 branches of government: the judiciary, the legislature, and the executive. Now, what has happened is here, the executive has taken certain action, Mr. Sivakumar being the head of the legislature. And whether there is mistake or misdeed, it is our contention that the correction or the punishment of the Speaker should be done in the Legislative Assembly itself, rather than by the court. Now, legal challenges to actions by the legislature or the executive is nothing new. But what is new is the approach taken by the judiciary on the current political crisis. In the past, we have the famous case of Fang Yuteng. It was a case that was filed in the High Court. It was decided by then Justice Chan Min-tat. There was no need to take the matter to the Federal Court. I do not know whether the judges of those days and the High Court judges today, what is the difference, that now we must take a route to go to Federal Court. And that is not all. In the case of Lim Chu Hock, a very colorful personality in Perak, although in some parties we also have colorable politicians. One specimen could not even keep his pants up and allow it to obey the forces of gravity, much to the embarrassment of the Malaysian public. Ladies and gentlemen, both Justice Chan Min-tat and Justice Yusofi Abdul Qadir has this to say. In the case of Fang Yuteng, he quoted ice cream made on parliamentary procedure, which says that the control of each house over its internal proceedings is absolute and cannot be interfered by the courts. And what is more, he says, as the learned author stated, it's a position reached by tacit consent, but he recognizes that the decisions of the courts are not accepted as binding by the House in matters of privilege, nor the decision of the House by the courts. Put it simply, decisions of the court, according to Justice Chan Min-tat, is not binding on the legislature. And what is more, in Lim Chu Hock, Dr. Yusofi Abdul Qadir has this to say. The court's power to make declaratory judgment is confined to matters justiciable in the courts, and the binding declarations which it could make under Order 15, Rule 16 of the Rules of High Court are limited to legal or equitable rights and do not extend to moral, social, or political matters. It's so clear. In the past, the judges have been very reluctant to step into the legislature. Fang Yuteng's case was over his disqualification in Parliament, and in Lim Chu Hock's case, he has two suits, one against the Speaker for failing to take the oath as an assemblyman, and the other was a challenge against the state of Perak. Now, this was the position taken by the court in the past. Now, what has happened to the present day? The Federal Court has stepped into the arena under its so-called constitutional interpretation of the Perak Constitution. Now, in the process, the court has made certain declarations. Now, declarations are only discretionary remedies in court. The court has a discretion whether or not to give. In the case of the suit by Zamri and 6 others against the Speaker, they filed altogether some 10 declarations from the court. And the Federal Court gave only 2. Among those declarations that the court did not give is declaration number 7, which reads, selanjutnya, satu perisyarahan bahawa plaintiff-plaintiff adalah berhak menghadiri dan mengambil bahagian dalam semua sidang Dewan Negeri dan